Welcome to This Explainer. Today, we're cutting through all that viral internet advice and those intense opinions you've probably seen, and we're zeroing in on the actual financial mechanics driving state child support systems. We're looking strictly at the source material here, actual federal statutes, landmark court cases, and practical legal strategies to really unpack this alleged $735 million kickback structure. Let's get right into it.
Okay, let's dive into this. $735 million. That is just a staggering federal figure, and it's allocated to states for the fiscal year of 2025 alone. But here's the catch, and it's a big one. This isn't money going directly to families. Nope. It's actually a specific pool of federal funds used to pay states based on their performance in collecting child support. So as you can imagine, legal advocates point to this massive figure as the absolute root cause of a highly aggressive enforcement environment. It's essentially a massive financial carrot dangled in front of state agencies.
To understand exactly where all that money comes from, you have to look at 42 U.S.C. 658A. This is the federal statute that actually authorizes those financial incentive payments. Now, critics often describe this as a highly controversial kickback structure. Why? Well, because states are essentially paid a bonus for the sheer volume of child support they manage to collect. So advocates argue this creates a huge financial incentive for states to treat citizens not necessarily as families in need of help, but basically as revenue sources used to capture those federal dollars. So let's move right into Section 1, the machinery, understanding Title 4D. And this brilliantly illustrates how that money gets divided up. Out of that huge $735 million budget under Title 4D, roughly $705 million goes toward those general state incentives for hitting collection metrics. But advocates highlight a deeply concerning slice of this pie. $30 million goes directly to training judges and attorneys. You know, critics raise some really serious conflict of interest questions here. Think about it. If the very judges adjudicating your case are funded by the exact same budget that demands high collection rates, is the system fundamentally compromised from the start? Which brings us to a really fascinating landmark Supreme Court case, Blessing versus Freestone. Historically, when custodial parents received government assistance, the state obviously had to spend money. Well, Title 4D was actually built to recoup those costs directly from the non-custodial parent. So based on legal interpretations of this specific case, critics argue that the modern child support system was actually built to reimburse state welfare spending. It literally wasn't designed to directly benefit the child. That brings us to Section 2, the conflict, due process and quasi-courts. Advocates frequently pose this exact incredibly important question. How can you possibly get a fair trial in a state court that is literally incentivized to find you guilty? If the state is receiving federal bonuses for establishing support orders, how can any individual expect a fair, unbiased hearing? This strikes right at the very heart of the 14th Amendment of the U.S. Constitution, which, as we know, guarantees that no person shall be deprived of life, liberty, or property without due process of law. But critics argue that due process, the fundamental right to a fair trial, to be heard, and to actually face your accuser, is nearly impossible to find in a system so heavily driven by collection quotas. To really get this, we have to contrast two distinctly different legal venues. On one side, you've got administrative quasi-courts. These are run by state agencies, like the Department of Revenue. They're built for absolute speed. And honestly, they function essentially like rapid collection agencies. On the other side, you have traditional circuit courts. These are run by actual judicial judges, and they're built to protect constitutional rights. They allow for proper legal discovery where you can actually slow down and examine the facts of a case. Now, in those rapid administrative courts, they operate on what many consider a pretty dangerous presumption, legally known as prima facie. Basically, if you fail to respond to a piece of mail, the system legally interprets your silence as your consent. They just presume guilt and immediately begin garnishing wages. And this administrative overreach actually became so severe that back in 2016, the Department of Justice had to step in and issue a Dear Colleague letter. They explicitly warned state courts against these kinds of unlawful administrative punishments. Let's look at Section 3, navigating the legal system. So the crucial point is, if you ever find yourself caught in this machinery, family law experts emphasize that you need to get out of the administrative process immediately. Step 1, object in writing within the specific window they provide, which is often just a tight 20 days. Step 2, explicitly demand that your case be transferred to a standard circuit court. And Step 3, proactively file your own formal custody case. You really have to establish your rights before the state steps in and dictates them for you. Once you're actually in a proper circuit court, attorneys point to one highly effective method to prevent those unfair calculations, and that is securing joint physical custody. Because these support formulas heavily weigh overnight stays, legally establishing shared placement ensures the calculations actually reflect reality. It completely bypasses that default presumption that you're simply an absent parent. Now, what's really interesting about this is that there are a ton of viral internet myths out there, claiming you can magically get a case thrown out just by demanding your co-parent's financial documents. But family law attorneys warn that this just isn't some magic trick. In standard primary placement cases, the custodial parent's income is actually often legally irrelevant. Demanding financials really only matters in a few specific scenarios, like when you already have shared placement, or if you're asking for deviation for special expenses, or in cases that also involve alimony. At the end of the day, knowing the actual law of your specific state is absolutely your best defense.
We've traced the federal incentives, all those deep due process concerns, and the necessary legal strategies to navigate it all. So I want to leave you with this one final thought. If this administrative system, fueled by a $735 million kickback structure, is structurally built and financially incentivized for state revenue generation rather than genuine family welfare, how must we radically rethink our entire approach to family court? Thank you for joining me for this explainer. Keep asking questions and keep learning.